welcome to session one, the Eastern Hemisphere session. The Western Hemisphere session will occur tomorrow evening and will comprise a different speaker lineup. I'm the chairman of the International Building Quality Centre and the founder of Lovegrove and Cotton Construction and Planning Lawyers. The IBQC is an altruistic, multinational, international thought leadership hub that develops international best practice building regulatory policy guidelines. Our board comprises internationally renowned legal experts and law reformers. If you haven't familiarized yourself with the IBQC website, I encourage you to do so and to have particular regard to our guidelines library. The conference will address ways to improve affordability and accessibility to construction dispute resolution for industry, government, and the global citizen. The conference will address ways to improve affordability and accessibility to dispute resolution right across the board. Now, a couple of housekeeping things. To reduce risks of technical problems, we ask the participants to turn their cameras off, as we've been informed that an overload could disrupt the stream. All attendees will also be muted to avoid disruptions, and questions should be directed to the Zoom chat feature. The questions will be addressed at the end during the panel session. All of our speakers are, in a word, preeminent, ranging from senior jurists to KCs to law reformers of international renown. Each speaker will be presenting for 10 minutes. The conference is recorded and available for viewing after the conference's conclusion. The PowerPoint slides will be published on the IBQC website. And finally, the IBQC and the International Codes Council are the hosts tonight, and the Society of Construction Law New Zealand is a co-sponsor. Thanks for the intervention and assistance of Mark Coldart. Now, without further ado, I will now introduce the Honourable Brian Preston, Chief Judge, Land and Environment Court, New South Wales, Australia. We're indeed blessed to be afforded the patronage of a preeminent jurist, and his honour's topic is the current challenges and the opportunities for improvement of dispute resolution systems. Your Honour, you are welcome.
Thank you. And I understand that you'll be able to share them. Thank you. So go to the next slide. So what are the challenges that I'm talking about? Well, the main problem is construction disputes cost too much and they take too long. Now, this cost and delay, bad as they are in themselves, adds to the party stress that is associated with the dispute. So this cost, delay, and stress can impede the resolution of the dispute, but they can also impede access to justice. Parties may feel that justice is simply out of reach. Next slide. So what we, next slide, please. So we need to redesign our construction dispute resolution system. Now, identify three components of this design. The first, which I'll address, is the dispute resolution institution. The second is the dispute resolution mechanisms. And the third is the case management process. Let's start with the dispute resolution institution. Now, when we're coming to design an institution, we need to look at the constitution, how that institution is constituted, its competence, and its expertise. Slide. In the constitution of the institution includes these matters. First, what is the type of institution? Is it going to be a court? Is it going to be a tribunal or some other adjudicative institution? Where are we going to position that institution within the judicial hierarchy? What jurisdiction do we give that institution? Is it going to be narrow? Is it going to be comprehensive? And what are the functions that the institution is authorized to exercise? Let's go to the second component, the competences. So when we're talking about the competences of an institution, we're referring to two types of competence. First, the constitutional competence, and second, the institutional competence. By constitutional competence, I'm referring to the proper role of the institution, both within the government, but also in how there is governance in the polity. Now, institutional competence is different. It concerns the capacity of the institution to exercise its jurisdiction and functions. And this will include the dispute resolution mechanisms, and I'll come to deal with that in a moment. Next slide. Let's come to expertises. So again, the expertises of the institution can be divided into two: contributory and interactional. By contributory, I'm referring to legal expertise, the skills, the knowledge, the experience that will contribute to the application and development of the law. And in this case, we're concerned with building construction law. And contributory expertise in building construction law is seen to be specialized legal expertise. Slide. Interactional expertise is a different type of expertise. As the adjective interactional suggests, it refers to the need to interact with other disciplines of relevance, not just law, but building, engineering, architecture, etc. Now, interactional expertise will allow the institution to understand and resolve the real issues that are involved in construction disputes, issues that may not be simply legal, but will be factual. So, coming back to the institutional design, then you can have an institution that has both types of expertise by having specialist decision makers, not only lawyers with contributory expertise, but also other technical experts. Next slide. So that was my first. The next is the dispute resolution mechanisms. So I've already said that institutional competence includes the dispute resolution mechanisms the institutions can use to resolve disputes. Now, what are these mechanisms? Well, they can be grouped in these categories. Firstly, adjudicative mechanisms. Secondly, consensual mechanisms such as mediation, conciliation. And thirdly, hybrid mechanisms such as med-arb or arb-med. And I've said that the institutional expertise includes having members with expertise in different areas of law and technical disciplines, but it also includes having expertise in the use of different dispute resolution mechanisms. Next slide. This allows the court to engage in what I refer to not as ADR in the sense of alternative dispute resolution, but rather ADR in the terms of appropriate dispute resolution. It involves matching the forum, the particular dispute resolution mechanism, with the FUS, the individual dispute. Next slide. If a court or institution that engages in appropriate dispute resolution can be described as a multi-door courthouse. It's a dispute resolution centre which offers a variety of dispute resolution mechanisms and then matches the appropriate mechanism, which is the forum, to the individual dispute, which is the FUS. Next slide. Now, that institutional design should also provide for case management of construction disputes from beginning to end. And the overriding purpose is to facilitate the just, quick, and cheap resolution of the real issues involved. And any case management process should meet these criteria. It should be simple, it should be relevant and proportional, and it should be effective and efficient. And this involves what is referred to as differential case management, tailoring the case management directions to fit the individual dispute. Next slide. Now, the IBQC Good Practice Guidelines, which will be discussed through this conference, assist in the design of the dispute resolution institution, the mechanisms, and the case management process. And they will facilitate access to justice for all in the construction disputes. Thank you for your attendance.
Thank you so much, Your Honour, and thank you for your economy of language and yet your ability to convey very, very important concepts comprehensively and with alacrity. Thank you so much. Now, Mine is the next topic, and my topic, if I could just have access to the PowerPoint, please. Ways to improve efficiencies and generate cost savings in construction dispute resolution theatres. And my paper is based upon learnings in terms of various law reform retainers where I've been deployed in Japan, Africa, and China, on some occasions on behalf of the World Bank, on other occasions direct governmental retention such as Japan. Next slide, please. Claims Advisory and Dispute Resolution Experts, HKA, investigated claims and disputes on 1,602 projects in 100 countries in a 2022 report. The findings are sobering. The combined value of the projects investigated exceeds US $2 trillion. Total claims analysed in the report exceeded $80 billion in value, while the cumulative overruns added up to 840 years. Next slide, please. Less than optimum construction dispute resolution systems are problematic in a number of respects. They work against utilitarian outcomes for parties in broad and legal proceedings. They by and large destroy commercial relationships. They lead to divergent rather than convergent outcomes. Therefore, one can argue that it's misleading to describe construction dispute resolution as dispute resolution in the adversarial sense, for dispute resolution in its purest form involves more than resolving a conflict. It's to resolve being the operative word rather than the imposing of an outcome on the parties. Courts and tribunals impose outcomes on parties by virtue of the fact that the parties have not been able to resolve the dispute themselves. It's third-party high-level intervention. Mediation and ADR enable the parties to fashion and collectively design outcomes on the basis of a mutuality of interests. Just because it is a dispute does not mean that there cannot be a meeting of minds and an affable, convergent outcome. An outcome where water is poured onto the fire, as it were, rather the infusion of benzene. The next optics are metaphorical. So with negotiation and mediation, one puts the fire out. Next slide, please. Whereas with divergent and adversarial dispute resolution, it's the antithesis of putting the fire out. The fire is fanned. Next slide, please. Now, some best practice protocols, and His Honour's mentioned the dispute resolution guidelines that the IBQC prepared, and as he said, we'll be extrapolating a number of key themes that come out of this. Mandatory front-end and early stage mediation, dedicated construction dispute resolution divisions, consolidation mechanisms that allow for the joinder of all relevant parties to a single proceeding, court or tribunal appointed highly qualified expert witnesses venerated by peers of good repute. Some best practice protocols. In keeping with the philosophy of convergent dispute resolution, where the mantra is to put the fire out, mediation will be mandatory, not optional, mandatory. Will occur shortly after legal proceedings are issued, i.e. within 6 months or so. It's well known that mediations culminate in ultimately about a 90% settlement strike rate, but often in certain jurisdictions, the mediation is the last thing that occurs before the trial begins. It's compellingly obvious that mediation should be front-end or early in the gestation of the dispute resolution journey to facilitate a circuit-broken outcome from the get-go. All actors responsible and affected parties will be required to attend the mediation. This allows the parties to better navigate an amicable solution. Well, it might not be amicable, but maybe that's a strong word. Let's say a solution by way of negotiation and the impartial guidance and cajoling of the mediator. Dedicated construction dispute resolution divisions. Best practice jurisdictions ensure that there exists within the courts or the tribunal specialized lists dedicated to construction dispute resolution, which concern themselves exclusively with that area of speciality. Within those divisions, arbiters will practice either exclusively or predominantly in construction dispute resolution. And that, by and large, is the case in many jurisdictions, such as the Victorian Civil Administrative Tribunal, and there are dedicated divisions that specialise in construction law in a number of jurisdictions around the world. So best practice jurisdiction, I've moved on for that one, please, apologies. Best practice jurisdictions will have mechanisms that ensure that all implicated parties can be compelled to participate in a consolidated set of legal proceedings. Thank you. Next slide. Court-appointed, highly qualified expert witnesses. In my experience, and this is based upon 30 years of construction litigation, in the order of 30% of the cost and time involved in construction dispute resolution, one can attribute it to the adversarial culture that in many jurisdictions it's become part of their DNA. Best practice construction dispute resolution recognise and manage well the expert witness testimony dynamic. There are those that are the view that the role of the expert witness is even more important than the role of the legal advocate. After all, when you're talking about building disputes, it's defects. How much are they worth? How do you diagnose them? What's the cost? Who's the allocation? That requires critical expert witness evidence. They would contend that most building disputes are about defects, cause of same, allocation, responsibility, and there are those that would contend that the expert witness is a paramount actor. I'm of that persuasion. A best practice expert witness protocol will have an expert witness accreditation system. It is submitted that expert witnesses that wish to offer their professional wares in a best practice jurisdiction will be accredited by an apposite government agency, appointed to court or tribunal panels of expert witnesses, required to complete annual professional development training to continue to hone their craft. Such is their importance. How a court-appointed expert witness system would operate. After the initiation of legal proceedings, there will be a directions hearing where appropriate experts are appointed to inspect, diagnose, cost, prepare a report, and copy the report to the disputant. So I was talking to a barrister the other day, and he said maybe there could be a directions hearing where at first instance, counsel for the parties jointly agree upon a script that cauterizes the gamut of the expert witness. The expert witness then agrees upon that, gets the sanction of the court, so the brief is crystal clear. So after the benefits of a court-appointed expert witness, I'm submitting multifarious, shorter trial length, earlier settlement, a reduction in costs of the proceeding, and a reining in of expert witness pugilism in that court-appointed experts will remove the adversarial modus operandi. There would obviously be much less need for cross-examination because a court-appointed expert would be far more persuasive in terms of an impartial form of evidence proffered to the tribunal or the court. Conclusion. Best practice construction dispute resolution ecology will feature, I submit, mandatory front-end mediation, dedicated building lists, an accreditation system which accredits expert witnesses, courts and tribunal appointed expert witnesses, the remuneration of both mediators and expert witnesses on the basis that the parties pay for their retention. I emphasize this point because not all jurisdictions can afford to underwrite expert witness evidence or mediators. So a user pays basis doesn't negatively impact upon stress treasury constraints. If these elements are enshrined in construction dispute resolution apparatus, I surmise that the cost of dispute resolution will dramatically reduce and will be conducive to a more holistic and utilitarian outcome that is in keeping with the philosophy of convergent dispute resolution. Thank you. Now, rolling on in rapid fire format. It is now my great pleasure to introduce you to an old friend and colleague of mine, Philip Greenham, historically and to date and continue a very, very senior, highly regarded construction law in Australia and arbitrator. And in terms of the dispute resolution guidelines that were jointly settled by a number of us, some of whom are here tonight, Mark did the lion's share of the actual drafting. So Philip's a senior construction lawyer and arbitrator in Melbourne, Australia, and an enterprise fellow at that sensational University Melbourne Law School. Philip's topic is good practice guidelines regarding dispute resolution, taming the wild world of construction dispute resolution. Thank you, Philip.
Thank you, Kim. Next slide. Thank you. We've already heard that building disputes are problematic, expensive, time-consuming. One thing which I think often flies under the radar and which should attract the attention of government and those who can develop and build dispute resolution mechanisms is the very negative impact on industry productivity and efficiency. And this is more important where you are looking at economies that perhaps are more challenged in terms of their capacity to have public infrastructure and the like developed. The percentage of wasted money in relation to disputes is estimated to be 0.04% of project value. And in the Australian construction industry, that equates to many hundreds of millions of wasted dollars, which governments could invest productively in infrastructure rather than in dispute resolution. And of course, in relation to residential disputes, it's not just the financial impact, but it's the very, very significant emotional drain and the damage caused to relationships and the like as a result of construction disputes. Thank you. Next slide. The philosophy which lay behind the development of the guidelines was simple. We wanted them to be suitable for all types of disputes and projects, major and minor projects, large and small disputes. We also wanted them to have cross-cultural relevance. So the guidelines are drafted in a way of suggestions and frameworks rather than rigid, detailed rules. And that is so that those who want to develop a construction dispute resolution framework in accordance with the guidelines can do so irrespective of the culture in which their economies exist and irrespective of the type of law, the legal landscape that they find themselves in. So we were looking for simplicity and flexibility in relation to the guidelines. Thank you. There are 9 principles articulated in the guidelines, and I'm now going to take you through those 9 principles. The first principle is the forum, the institution which His Honour has spoken about. We think that needs to be supported by legislation. It needs to have the endorsement of, it needs to have the strength of the state behind it. We also think it's important that it's generally open to the public. The question of the development of construction law jurisprudence and the awareness of how the thinking on how various construction law issues ought to be resolved is developing, ought to be known to all participants in the industry. And if we have a closed system, then you find that the awareness of how that legal thinking is evolving becomes restricted, and that is a negative impact on the industry. The second principle, the system needs to be adequately resourced. Needs to be adequately resourced to avoid delays. Delays bring the system into disrepute and increase the aggravation and the distress which the parties participating in the system experience. And the system must be adequately resourced so that it can attract people with appropriate qualifications. Having appropriate qualifications is an enormous benefit and of enormous importance to a successful dispute resolution system. Those people who are experienced and qualified and have the gravitas and the wisdom to be able to command the respect of the parties and steer disputes quickly to a satisfactory conclusion are rare and valuable, and they need to be adequately remunerated and adequately qualified. Thank you. Next slide. Principle 3, and I've already mentioned this, respected members. The ability of the person who is either going to help chaperone the parties to their negotiated resolution, or who is going to impose a decision on them, the inclination of the parties to be satisfied, even if a little disappointed, but ultimately to be satisfied that the process has treated them well, depends very much on the way the member who is conducting the process does conduct the process and conducts himself or herself, and that calls for respected members being involved in the process. Cost should not be a barrier to participating in the process, and the costs really fall into two buckets: the administrative costs, so the costs which the tribunal itself might call for in terms of helping to assist in its running costs, but more importantly, the costs of the process. And the costs of the process can become horrendous. Kim has already mentioned that. Process costs can very often dwarf the value of persisting with a dispute. And if process costs can be contained, then the parties' focus can remain on the substantive issues which have given rise to the dispute, rather than trying to retrieve very significant sunken costs that they have invested in the process. Thank you. Next slide. Principle 5, efficient processes. And His Honour has mentioned the various stages of dispute resolution process which are important, and these are highlighted again here. The pre-issue stage, so in Victoria, where I am from at the moment, and I'm sure in many other jurisdictions around the world, there is now a requirement that legal advisors to parties certify that they have given proper advice to their clients prior to the issue of proceedings, and that they have sought to resolve the matter. So encouraging parties to focus on resolution of the dispute prior to the issue of proceedings is important and valuable. The ability to initiate the proceedings should be simple, efficient, inexpensive. Information exchange, discovery, the common law curse, perhaps not so much, of course, in the civil law world, very rarely brings significance of value. And in those cases where there has been very limited discovery, perhaps following the IBA rules in arbitration, I think people have generally been very satisfied, and I think most civil law lawyers would scratch their head at the way common law lawyers become so preoccupied with discovery, and I think that there needs to be a very tight control on information exchange. Case management. The tribunal member who is managing the preparation for the hearing of the case needs to be focused, disciplined, experienced, so that they can understand how parties might either deliberately or through ineptness mismanage the system and not move through the system as efficiently as they can. And then the giving of evidence. The rules of evidence should generally not apply. The rules of evidence don't necessarily bring value, which the question of the weight which any particular evidence might be given can't equally bring. Thank you. Next slide. Experts. Kim has already mentioned about experts, the role of experts and how they should be appointed by the tribunal, and I agree with that. They are not advocates for the parties. They should be bound by practice notes to their duties to the tribunal and their duties to be frank and independent. The engagement of the expert by the tribunal can remove a lot of contention and adversarial tone that Kim has already mentioned. And if experts are to be engaged separately by the parties, then there should be significant focus on joint reports and the efficient and timely preparation of joint reports. Thank you. Next slide. Appeals. Appeals are necessary in certain circumstances, and the availability of an appeal process can help parties have confidence in the process, but they should be very limited to important questions, perhaps of general application, and where there is a significant material impact in relation to the question under appeal, and where there is a reasonable prospects of success. Thank you. Next slide. Principle 8, the process. I think Kim mentioned a target for having the mediation occur within the first 6 months. In the principles, we set out a shorter target than that. Indeed, there's an aspirational target of 120 days from issue to conclusion, which, if you have active tribunal members and experienced participants in the process, there's no reason why in most cases that can't be achieved. Active mediation, and I am one for a mediator not sitting on the fence entirely, but sometimes giving some guidance to the parties, and a mediator that is prepared to express their opinion to the parties can be of significant assistance. Next slide, thank you. The last one. Early settlement should be encouraged, and the short timeframes, which I've already mentioned, is one aspect of encouraging that. The early and active mediation, the active engagement of the mediator, is another aspect of encouraging that, and having trained personnel involved in the process is another aspect relevant to the encouragement of early settlement. Thank you, Kim.
Thank you so much, Philip. Now, Gideon Vasterwezen. Gideon is a global compliance and risk expert who specialises in Indigenous and traditional affordable shelter with Australian First Nations people and African urban constructs. Gideon's topic is culturally appropriate mediation in developing constructs, role of mandates in achieving effective dispute resolution. Gideon, over to you.
Tim, thank you very much. And, I'm very privileged to be sharing at the stage with such learned experts around me. And as probably the only non-lawyer, I'm very impressed what I'm hearing. But I also just would like to share from my side as an urban planner and a risk practitioner, my understanding of mediation, the importance of that, of course, referencing my African roots, and also so next slide, please. Can you see the next slide?
Yes,
yeah.
We can.
Oh, there it is.
Yep.
Thank you very much. Sorry. The focus for me is twofold today, is to talk, and other speakers have alluded to mediation. I want to talk, and I'm going to lift out one critical aspect as part of the mediation, and it's called the mandate. The mandate that underpins effective mediation. I'll spend a couple of slides on it, do some references to international law and experiences back in Africa and probably closer to home in Australia. And then I will end my discussion focusing on more culturally appropriate mediation and the issues of unconscious bias. So, next slide, please. Thank you very much. So I just before I kick that off on the importance of mandate legitimacy, first-hand experiences as a young professional in Africa when I worked in a low-cost housing environment where we had a significant dispute. It was just post-apartheid, the release of Mr. Nelson Mandela. South Africa was still going through significant turmoil, and we as developers and financiers and planners had to come to grip as to what this new order would mean for us. We learned very quickly the importance of effective mediation instead of trying to go down the legal route, especially where you worked with communities that were previously disadvantaged, and they looked at the law and didn't respect the law because the law to them was alien, and they felt that the law was obstruction to their ultimate outcomes. And I can vividly recall, as representing my organization, across a table where we had to engage with civic organizations, and I recall dealing with the Secretary General of the South African National Civic Organization, who's actually today South Africa's president, Mr. Cyril Ramaphosa, and really became very much aware of what a strong adversary he was, but that was not the approach. So we both decided to work together to find an absolute outcome. So the mandate on the slide is critical because it gives legitimacy to the process and the outcomes that we are seeking. In the slides, I refer also to specific functions that the mandate will try and bring to the fore. It is that legitimacy that's which we are after. It gives the mediator that authority and leverage. It provides also clear instructions to the mediator and the two parties. And also it set the parameters, as to dispute resolution and process of outcome. And on that slide, I just referred to, and using a bit of international law in African context, for example, where we saw the importance of mediation mandates, and these are even signed up and passed through the United Nations Security Council, the African Union's Peace and Security Council. And also we have witnessed this firsthand in further fields where we would see significant disputes about territories in Africa, and where, for example, the role of the mandate was critical, and that was our reference point. Next slide, please. So in my next slide, so I'm seeing that, yeah, thank you, is basically an instruction to the mediator. And it's from my own experience, mediators who deviate from that mandate risk of actually being replaced. And there's a case study that I'm referencing here, for example, in Madagascar, where the South African development community sidelined its mediator, the then former Mozambican president, Joaquim Chissano, as he ignored the mandate by accepting that Mr. Ravamohana could not return to Madagascar at that point. So basically what we do see through mandates are also some paradoxical effects. They, on the one side, limit mediators' flexibility, but also can greatly complicate the mediation overall. But I think the critical element I made in the earlier slide is the importance of bestowing the authority and leverage what is so critically important. Next slide, please. So yeah, in this slide, I referenced that parties can withhold consent in different ways. First of all, you can reject mediation emphatically, and we've seen this through the Libyan rebels in 2011, when there was endeavors to achieve a peace accord. They can reject, or parties can reject the mediating organization. For example, again, in Madagascar, for example, the coup regime ignored the South African Development Confederation in 2010 on the grounds that it was biased, and I'll talk about bias a bit later. So and then of course the mediator can be replaced. I shared with you the example of the former president Chissano of Mozambique. So the risk here is that is a failure to obtain a strong mandate from the parties impacted can weaken the mediator's authority and credibility. And it also can cause, both domestic and international stakeholders to lose confidence in the overall process. Next slide, please. Yeah, in this slide, and I'm coming to the second part of my discussion, relates to cultural appropriate mediation. And I think from the outset, we would need to acknowledge, and the experts probably would agree with me, is the issue of complexity that drives cultural differences. Different cultures have different sets of values, and I've experienced this very much back in South Africa, where we had disputes, again, when I worked in a low-cost housing environment, where the mediator was of a certain ethnic persuasion, a Zulu at that point in time of the ethnic group, and the dispute matters that he had to oversee related to impacting different tribes. And it was very obvious that the tribes, in this case, both Xhosa and Sesotho, did not appreciate or did not actually accept some of the points handed down. So very important is, how do we, ensure that mediators are being given the additional skills and knowledge then to assist parties in an absolute objective way. So, and it can, of course, be seen very daunting to mediators. and no doubt, there needs to be access to knowledge and other support that mediators can rely on. Next slide, please. So the next slide, Kim, if we could move on. Yeah, thank you very much. So in this slide, I just want to highlight some points pertaining how to handle specific aspects of mediation. Mediators themselves should be aware of their own potential bias, which could be defined as a prejudice for or against something. So, and again, I use an example in the slide where I state that it could be frequently understood or be seen that, for example, criminality could be associated with Indigenous people. Now, this is a bias, but a potential real bias, and if a mediator is not even aware that they are doing it, mediators then should be exempt from this trap, or just try and apply some sort of lens to that effect. So two common problems here that I see is communication barriers, and also potentially culturally driven interests. So next slide.
1 minute to go, Gideon.
Thank you very much. So yeah, probably just very quickly on this, Kim and everybody else, this is the importance of language as a social instrument, also reflects a certain culture, and in mediation, this is very important. For example, in the Indigenous environment, the use of terms and terminology, and I'm currently dealing on a project where we are doing some environmental issues in responses in delivering a medical center in regional Victoria. The use of the terms fauna and flora by the professional team was frowned upon. And I think most of our legal experts and legal knowledge audience here would probably understand as to why this was deemed a significant issue to the Indigenous community, because to them, or a large part of them, it brings hurt and going with that. Thanks, Kim. Last slide. Yeah, and so yeah, can we just move forward on the slide and just go? There's one more slide to go, Kim, since I've got about 20 seconds left. And then I just want to conclude is that, yep. Yep, this is the last one. So mediation should be seen as a worldwide dispute resolution tool, should motivate mediators to broaden their knowledge and improve their skills and cultures, where, for example, both when it's critical. If the mediator fails to consider cultural factors where there are crucial elements of the whole, disputants may have a very poor experience in the mediation process. And no doubt, a number of you probably are dealing with these type of matters every day. Yeah. Thank you very much, Kim. I will stop there.
Thank you, Gideon. That was a very interesting perspective that you brought to bear, applying some of your insights in terms of learnings in Africa. Now, Richard Manley, Dr. Richard Manley is abroad, and he has given me permission to, before that, I've made a mistake. It's Bob Whittaker. Now, Bob Whittaker is a very old friend of mine. He's an ex-national president of the Australian Institute of Building, and he's a deputy chair of the International Building Quality Centre and an expert witness. He presents with a phenomenal amount of boots on the ground experience. Bob, looking forward to your talk.
Thank you very much, Kim, and thank you, ladies and gentlemen. As my colleague just pointed out, I am a building consultant and expert witness, but I am also a practicing builder. So I'm fully au fait with the construction techniques that make for good building. Now, could we go to the first slide? The expert witness must have very robust qualifications and experience-based credentials. Now, as we're going to discover in the course of this short talk, what constitutes that is critically important. Too many members of the public, too many parties to a dispute are let down by what is inherently poor witnesses. However, and this is because there is no uniform accreditation mechanism for the deployment of expert witnesses. This means that the outcomes are uncertain and variable. They're unreliable. If you were going to do the same thing again with another expert witness, often you get a totally different result. And this is not good for the public or our industry at large. Next slide, please. Now, this is exacerbated by the problem of adversarial expert witnesses. Okay, now the construction sector is well versed with that because of the contractual arrangements. But we don't have time to talk about the merits of different contractual arrangements. But what we are about is doing away with the adversary nature. It is not unusual for a plaintiff's expert witness to be too generous in terms of rectification costs and assessment, but they're going to be hard on the other side. Equally, it's not uncommon for the defendant to be too miserly with regards to rectification costs. The net effect is a considerable disparity of evidence, which leads to protected and very costly litigation and an erosion of confidence. Next slide, please. Now, what do we recommend? Okay, the development of an accreditation regime to ensure that the very best expertise is available and that it can be used in construction dispute resolution. Now, to those ends, I make note of, well, a court-appointed panel or tribunal-appointed panel of experts would go some way to addressing this issue. Next slide, please. So if we had a single expert witness, one source of truth, if you like, for both parties, the proposed system would involve the following steps. The legal proceedings would be issued. The court or tribunal would convene the directions hearing. An expert witness would be appointed by the tribunal or court. The expert witness will be should be remunerated on a 50-50 basis by each party to the dispute. The expert witness will inspect and prepare reports in terms of diagnostics and costings. The expert witness would also identify those responsible for the defects. And bearing in mind, ladies and gentlemen, one of those defects is prolongation, a contract running over. At 7, the report will be made available to both parties and the tribunal member. And it will also be made available to any mediator that is charged with the responsibility of trying to get the matter settled. In some circumstances, the complexity of the case might determine that it requires more than one expert witness, and that's got to be understood. Engineers know a lot about structure. They know a lot about services. Architects should know a lot about construction detailing. But the nature of the dispute should determine the nature of the expert required. And that's where you need a court-appointed, tribunal-appointed expert witness. So the tribunal should have the power to appoint additional expert witnesses with skills that are tailored to a particular complexity. If the matter ultimately goes to trial, the court-appointed expert witness will be afforded the priority and precedence with regards to their assessment. Next slide, please. Now, the benefits of this, to my mind, are pretty self-evident. Let's go through them. Impartiality will be part and parcel of the court-appointed, tribunal-appointed expert witness. This means that each party is starting from the same start line. It will be better conducive to early settlement, a shorter trial length. In some cases, huge cost savings and legal fees. Better outcomes for all disputants, i.e., an outcome more quickly reached and which is more reliable and more verifiable. And in light of the fact that the expert witness will be jointly retained, the costs associated with the expert witness would be dramatically slashed. Next slide. Now, in conclusion, I'm totally confident that if this was followed through, disputes would actually get the experts they deserve. Not experts with genuine expertise, not self-appointed expertise, not the expertise of haranguing the other party with excessive costs and excessive opinion. Now, that could only be for the betterment of the industry and the building profession as a whole, and not to mention the legal profession as well. Now, Kim, that concludes my short talk, and thank you very much.
Thank you very much, Bob. Thank you very much indeed, and I appreciated your practical boots on the ground perspective. And what you're saying is consistent with the theme that's emerging in this conference. Now, moving on, because I want to ensure there's time left for questions at the end. Dr. Richard Manley, Richard's abroad at the moment, and he's written a fantastic paper that will be published on the IBQC website in long form. And what we've got here is a synopsis of some of his key takeouts. Richard's given me permission to address this paper on his behalf. Dr. Richard Manley is a preeminent Australian construction barrister and arbitrator in Australia. His topic is how to fast-track construction dispute resolution, best practice interlocutory logistics to fast-track the dispute resolution thinking. And some of this is the latest cutting-edge thinking on point. So if we could go to the next slide, please. One of the general duties or paramount objectives that an arbitral judge, tribunal judge should observe at all times is to adopt procedures suitable to the circumstances of the dispute, to avoid unnecessary delay or expense, to provide a fair and efficient means for the final resolution of the dispute. Next. So some of the innovative procedural measures that Richard has identified and crystallized are Scott schedules, Redfern schedules, Reed retreat, Sachs protocol, and Kaplan opening. Next slide, please. Now, you can just quick scan the top of that. I won't read it out to you, but I'll just give you a few seconds to look at the top dark blue column. So you can just digest. I think that's enough time to reflect. As I say, these papers are going to be on the IBQC website and they will be downloadable, as it were. So the benefit of the Scott schedule, Richard articulates as being to increase the possibility of settlement, the identification of clarity of areas of argument, allow identification of differences, assist in avoiding confusion at hearing. One convenient document that sets out competing claims. So it brings a bear an organizational rigor. Next slide, please. Now, this is an example of the claimant's Redfern schedule. So this is the second example of an enlightened system. I'll again let you just take that in for a few seconds. Thank you. We can move to the next slide. Thirdly, the Reed Retreat. The Reed Retreat is a conference of arbitral tribunal members where there is, for example, a panel of 3 members. The aim is to stimulate the members of the tribunal to familiarise themselves with the documents so they can engage with other tribunal members in a meaningful way. Next slide, please. The Sachs Protocol. The aim of the Sachs Protocol is to assist the tribunal in its dealings with experts. After the parties have submitted their first briefs, the tribunal invites both parties to provide the tribunal and the opposite party with a list of 3 to 5 persons they consider fit to serve as an expert for the determination of a particular question. In a second step, the tribunal will choose 2 experts from each of the 2 lists and appoint these experts together as an expert team. Again, the theme running through this is to eliminate the adversarial dynamic. Next slide, please. Kaplan opening. Intended to be a hearing before the tribunal after the first round of written submissions and witness statements have been delivered, but prior to the main hearing. The main advantage of this process is that it adds convenience and efficiency to the tribunal's decision-making. The tribunal gets a better understanding of the case sooner, which facilitates preparation for the ultimate hearing. Further process: treatment of preliminary issues, proceeding by an agreed statement of facts, proceeding by an agreed list of questions or issues, and a limited stop clock hearing. Next slide. In conclusion, as a general proposition, all litigants want results faster and cheaper. That's axiomatic. Rather than litigating, litigants more often than not just want a resolution of the dispute. Resolving disputes efficiently is not necessarily achieved by proceeding fast and doing things cheaply. Philip's made that point earlier on. What needs to be considered the concepts of time, cost, and quality. So that concludes Richard's talk. And I reiterate, there's a long form document that will be published on the site, and it's a very, very learned piece of writing. Now, the next presentation is by Her Honour, Judge Birchall, County Court Judge Victoria. And Her Honour has submitted a pre-recorded session, and it will now be played. And what's coming through here is very innovative, and it's a best practice expert witness protocol that she applies, and I think it's international best practice. Her Honour's topic is experts in your courtroom, promoting settlement, saving time, and getting the best evidence by appointing single joint experts. So we'll just see how we go with this recording.
I wish to pay my respects to the traditional owners of the land on which we meet and pay my respects to their elders, past and emerging. My topic is in relation to single joint experts, and following discussions with the County Court of Victoria's Building Cases Users Group about potentially controversial provisions contained in the Commercial Division's practice note, which was launched on 1 August 2022, concerning expert evidence and their relationship with provisions contained in Part 4.6 of the Civil Procedure Act Victoria 2010, defined as the CPA, I considered the rationale behind the relevant CPA provisions and the new practice note to order the appointment of a single joint expert as the default position should parties wish to adduce expert evidence at trial. The starting point is the Expert Witness Code of Conduct, which is contained in Rule 44.01 of the County Court Civil Procedure Rules and Form 44A. It states that an expert witness is not an advocate for a party and has a paramount duty overriding any duty to the party to the proceedings or other person retaining the expert witness to assist the court impartially on matters relevant to the area of expertise of the witness. Further overarching obligations are contained in Section 10, subsection 3 of the CPA, and relevantly, an expert must act honestly, must cooperate in the conduct of a civil proceeding, must not mislead and deceive, must narrow the issues in dispute, must ensure costs are reasonable and proportionate, and must minimise delay. Section 21, in relation to misleading and deceptive conduct, was particularly considered in the recent decision of the Supreme Court in Hudspeth. Justice Dixon instituted an inquiry under the Civil Procedure Act into the conduct of the plaintiff's lawyers and one of her experts. He found that the plaintiff's senior barrister breached his obligation not to mislead and deceive, and to disclose the existence of documents in relation to a third expert report. His Honour further found that the expert had breached his obligation not to mislead and deceive and had failed to adhere to the expert code of conduct. The facts of that case involved the production of 3 different expert reports. There were 3 different versions because the second report had been dictated by the plaintiff's solicitor to the expert's assistant without the expert's approval or knowledge. However, the second report was adopted by him. The change was in relation to some assumptions of facts, which contradicted the first report of the expert, in which he had been told by the plaintiff that she had not previously seen evidence of vandalism of the soap dispensers in the school's toilets. When giving expert evidence, the expert was asked during the course of the trial to read the assumed facts contained in his report. The expert referred to the first report. However, the plaintiff's senior barrister referred to the second report. Due to the inconsistencies between the 2 versions they were relying on, it was soon discovered that each was referring to a different report. Then, during cross-examination, the expert was questioned about the inconsistencies, and he disclosed that there was a third report which had been dictated by the senior barrister, when the senior barrister had recognised there were inconsistencies in the facts between the first and second report. Further, he wished to make changes after the evidence given by the plaintiff during the trial, which was then incorporated into the third report and agreed between counsel and the expert. The difficulty in relation to the third report was that it was provided to the plaintiff's senior counsel, but it was never served on the solicitors. This was in breach of Rule 44.03 sub 3 of the County Court Civil Procedure Rules. That is, that when an expert has changed their opinion on a material matter expressed in an earlier report, or where a supplementary report is provided, it must be provided to all parties forthwith. On appeal, the Court of Appeal determined that the plaintiff was denied a fair trial in relation to comments made to the jury by the second respondent's counsel in final addressed in relation to the performance of the plaintiff's counsel and solicitors in relation to their overarching obligations regarding the expert evidence. Ultimately, the court made adverse cost findings against the barrister and solicitors. The lessons for the court arising from Hudspeth include a move towards parties agreeing to the facts and assumptions on which an expert opinion is to be provided, and that lawyers must comply with the provisions under the Civil Procedure Act and the rules in serving appropriate supplementary reports if they come into existence. If we look closely at Part 4.6 and the requirements under the Civil Procedure Act in relation to single joint experts, the objects are found in Section 65F, which are to enhance the case management powers of the court and to restrict expert evidence to what is reasonably required to resolve a dispute. And there's an emphasis on the primary duty of an expert witness to the court. The court further has the ability to give directions in relation to expert evidence, such as limiting the expert evidence to specified issues, limiting the number of expert witnesses, and the provision of appointing single joint experts. There are also further provisions in relation to conferences and joint reports if the parties are in the realm of parties' own experts. There are further directions in relation to single joint experts that a court may order that an expert be engaged by 2 or more parties, that a court may make an order for the engagement of a single joint expert at any stage of the proceeding, and in making an order to engage a single joint expert, the court must consider the following factors. These include whether the engagement of 2 or more expert witnesses would be disproportionate to the issues and the amount in dispute, whether the issues fall within a substantially established area of knowledge, whether it's necessary for the court to have a range of expert opinion, whether it would expedite the trial, whether the single joint expert is selected by agreement, failing which that there is a direction of the court, that the expert must consent to the engagement, and that the parties must disclose previous communications on the issues concerned. Further, the expert is off limits to the parties on issues pending in the case. The report may be tendered by either party, and it is made clear that a single joint expert is not a court-appointed expert. In relation to the instructions for a single joint expert, the parties must endeavour to agree on written instructions and facts and assumptions, and if they can't agree, they have to come to court. Further, there's no additional expert evidence without leave of the court. The Witness Code of Conduct at Clause 3 states that an expert must exercise their independent judgment in relation to the conference, and that they have to agree not to act on any instruction, request to withhold or avoid any agreement. Further, they have to endeavour to reach agreement with other expert witnesses on any issue in dispute, failing which they have to clearly identify the basis on which those issues are in dispute. The history in relation to single joint experts is found in the recommendations in the 2008 Victorian Law Reform Commission Civil Justice Review Report. And in particular, there was a finding that one of the main purposes of the rules is to ensure that, if practicable and without compromising the interests of justice, expert evidence is given on an issue in a proceeding by a single expert agreed by the parties or appointed by the court. The VLRC report was heavily relied upon in relation to the findings in the New South Wales Law Reform Commission report and the previous New South Wales Uniform Civil Procedure Rules 2005. The now retired Chief Judge of the Common Law, Peter McClelland, pioneered the use of single joint experts in the New South Wales Land and Environment Court and in common law. There was pushback by the New South Wales practitioners, but there was cultural change from 2005 in relation to the independence of the single joint experts and assisting the court rather than being an advocate for the party arising from the party's own expert model. It was noted in the New South Wales Law Reform Commission report that the primary objective of the appointment of a single joint expert is to assist the court in reaching decisions by promoting unbiased and representative expert opinion. Another important objective is to minimise costs and delay to the parties and to the court by limiting the volume of expert evidence that would otherwise be presented. The Commission concluded that under the present system, there existed significant problems with the way expert evidence comes before the court. These problems form a powerful argument in favour of amending the rules to provide a further option to the court, namely to order the use of joint expert witness. The Commission believed that the use of the joint expert witness could reduce the partisanship that is so closely associated with the expert witnesses called by each party and encourage the use of experts with balanced representative views. The New South Wales report relied on the 1996 UK Wolf report, in which it identified the use of the expert witnesses as one of the most aggravating factors, finding that it added to the expense, delay and complexity of litigation. the remedy under the Wolf Report was to shift the role of the judge as a judicial manager, and that the judge should be empowered to influence litigation in order that a degree of proportionality be maintained between the importance and the complexity of the dispute and the costs on the individual and the public. The Wolf Report concluded that a single expert is much more likely to be impartial than a party's expert can be. Appointing a single expert is likely to save time and money and to increase the prospects of settlement. It may also be an effective way of levelling the playing field between parties of unequal resources. These are significant advantages, and there would need to be compelling reasons for not taking them up. Therefore, the advantages of a single joint expert are reduced time and cost, narrowing of issues, it promotes settlement, and reduces bias inherent in an adversarial system. The disadvantages are limits on use, engagement of shadow experts, which may increase costs. It may suppress legitimate differences of opinion, and there may be a perception of an abdication of the court's decision-making function. The County Court's experience some 12 months later, after the launch of our practice note, in which there was a default position of the appointment of a single joint expert should the parties wish to adduce expert evidence at trial, indicate that 32 cases consented to the ordering of a single joint expert, and 43 cases ordered parties' own experts. That indicates there's been a 43% increase, 43% of cases relying on expert evidence in the building cases list in which they've consented to single joint experts. In my view, litigants appearing in the County Court have benefited greatly from the shift away from individual experts, as judges are able to deliver judgments quickly, saving on average some 3 months writing time. Trials are shorter, in which there's a 2 to 3 day decrease in expert witnesses in the witness box. Settlement is more probable, and the process leading up to trial is more efficient. We're also confident that the quality of judgments handed down by the County Court has improved because the real issues are more readily brought to light, and the merits of each party's application can be more accurately assessed with the help of less adversarial expert evidence. Thank you.
That was outstanding. And I'd commend it. The International Building Quality Centre is all about commending international best practice, and I think that's an international best practice protocol. And it really encapsulates so much of what we've been discussing and advocating this evening or this morning, wherever in the world you may be. So thank you so much, Your Honour. Now, my friend Mark Coulthard, he's a senior barrister and arbitrator in New Zealand. He also collaborated and helped on the good practice guidelines. Mark is talking about the necessity for stronger institutions, the need for specialist construction dispute resolution tribunals. Over to you, my New Zealand brother and Kiwi friend.
Right, well, kia ora, Kim. In Aotearoa, New Zealand, it's the Te Wiki o Te Reo Māori, which is the Māori Language Week. I'm conscious we have an international audience here, so just to explain very briefly, Māori are the indigenous people of Aotearoa, New Zealand. They entered into a treaty partnership with the British Crown in 1840, and some would say that the parties to that partnership have been arguing ever since about what that means, and that strikes me as quite similar to many of the construction disputes that we see come across our desk. But the relevance of that is much of what we do in New Zealand in relation to the administration of justice. It recognises that treaty partnership between the Crown and Māori. And so within that, with that in mind, I'd like to just use one of my minutes to introduce myself in Te Reo Māori for the benefit of everyone here, so you can know me slightly better. And I'm going to do what's called a traditional Māori pepeha, which is about sharing your connections with the people that you're talking to. And I also think that's important in this online environment that we are operating in, these days that human connection is more important than ever. So here goes, just for 1 minute. Kia ora tātou, so that means greetings to everybody. Ko mangawhao tamanga. So mangawhao is Mount Eden in Auckland. That is the mountain where I was born very close to, and it is very close to my heart. Ko Waitemata te Moana. So the Waitemata Harbour, the sparkling Waitemata Harbour outside Auckland is the sea that I relate to. No tamaki makoto aho. I am from Auckland. Engari, and this is the interesting bit. Ko te rana e rana te whakapaparanga mai. So my ancestors come from Scotland, that's ko te rana, and Ireland, Airana. Ko Kolta toku whānau, my family name is Kolta. Ko Mark toku ingoa, Mark is my name. So that's just a little introduction to recognise Māori Language Week. The structure of what I'm going to talk about is going to be relatively brief. Firstly, the general topic, of course, is the need for specialist construction dispute resolution tribunals. And so it really begs the question, firstly, why is construction special? So I'll deal with that first. Secondly, I'll cover what I see as the advantages of specialist construction dispute resolution tribunals. I will cover then, thirdly, very briefly, the disadvantages of specialist tribunals. And lastly, I'll touch upon the IBQC guidelines, bearing in mind that Philip Greenham, who I was privileged to meet here in Auckland a few months back, has already taken us through in detail what the guidelines involve. Just bear with me while I rearrange something on my screen here. So dealing firstly with why is construction special? Well, what we have already heard from Kim in the introduction is that the value of construction disputes around the world is growing. It's soaring, some articles say, at a great rate. And Kim pointed out in an article that he's written recently that the average value of construction disputes internationally is at around that $50 million mark. So it's a staggering amount of money for an average construction dispute. And of course, that doesn't recognise that there are hundreds of thousands of construction disputes at far lower numbers, which are equally significant to the parties. Kim has also referred to the report by HKA from 2022. I don't want to go over the same ground, but I just think it's worth emphasising that the numbers that Kim mentioned from the HKA report about the value of construction disputes are just staggering. So in terms of construction as a contributor to the world economy, the figures that came out of that report, I'll remind you, is that the combined value of projects investigated in that report exceeded $2 trillion. And that the claims, that is the disputed claims in 2022 that HKA investigated, exceeded $80 billion in value. And the most staggering figure of all, I believe, was the final figure to mention, that the cumulative cost overruns added up to 840 years. So for practitioners who've ever been involved in a delay claim, you do see some extraordinary numbers there, but that cumulative delay really is staggering, and it underlines how critical finding ways through these disputed issues is to economies in general, and obviously to the parties involved in the disputes. I also acknowledge what Phil Greenham has said about the hundreds of millions of dollars of waste in construction disputes, and that was in Australia alone, let alone internationally. So the first reason, obviously, that construction deserves some special consideration is the value and the importance to the economy nationally and internationally. The second reason that construction needs a special tribunal is that there are very special technical challenges with construction disputes, and they are only getting harder to manage. I was fascinated to hear the previous speaker and one previously talking about expert evidence. The reality is that construction cases have become very heavily reliant upon detailed technical expert evidence, and even more so than ever, it's become vital to have people deciding those cases who really can come to grips with that really difficult, complex technical evidence. I had my first insight into that when I was a teenager, and my father's one of his careers in his very colourful life was as a builder, and I would go to building sites and hear him talking to contractors, and they might have well been speaking a foreign language. But construction is technical; it has a language all of its own, and so really you need specialist tribunals who can come to grips with that easily. So I see those as the key drivers. So what has the response been around the world? Well, in major economies, specialist courts have been developed to deal with construction disputes. The most famous of all, and the institution that has really driven the development of the common law in construction, is the Technology and Construction Court in the UK. That court is celebrating this year its 150th anniversary. So it is the longest standing specialist construction court in the world. We are very, very lucky on the IBQC to have a former TCC judge as one of the members who has helped develop the guidelines. But so really that is the leading specialist court in the world. But around the world in other jurisdictions, in Dubai, in Singapore, Hong Kong, and of course in the state courts in Australia and Victoria and New South Wales, there have been specialist courts developed to deal with construction. The other response, of course, has been the embracing of arbitration as an alternative method of dispute resolution. But that has limitations. For these large $50 million plus projects, the cost of arbitration can be borne by the parties in the most part. But in the huge majority of smaller disputes, the cost of certainly of international arbitration is out of reach of the parties. And so that has been ruled out by many parties because of the cost. Arbitration also has limitations in terms of not being able to deal usually with multi-party disputes and issues sometimes with enforcement of arbitral awards in other jurisdictions, and sometimes the reluctance of parties to go to arbitration because there are no appeal rights in general, or appeals are severely limited. But the main limitation there is cost for these very complex and expensive cases. So that leads us to a point where when we were developing the IBQC guidelines, we leant strongly into suggesting and recommending that specialist state-funded construction dispute resolution tribunals are put into place to provide access to justice for parties that are in construction disputes, which are not $50 million and above in value, but more everyday, to ensure that those disputes which really drain the economy are resolved. And really, I said I would refer to the advantages. They come down to these three, I believe, which are that they provide a fast, an efficient, and a fair process to the parties. And those are really the key ones. You don't need to have a cheap and fast process that isn't fair or efficient, but you need all three of those. In terms of the disadvantages of a specialist construction dispute resolution tribunal, this is a little bit like the chapter in Alan Carr's Easy Way to Stop Smoking book, If anyone has ever read that, there is a chapter in that book on the advantages of smoking. You turn to that page and it's blank. It's an empty page. There are no advantages of smoking, according to Alan Carr, and I believe that to be true. And likewise, there are no disadvantages that I can see to a specialist dispute resolution tribunal. Obviously, there is a cost to set that up, but that is repaid in multiples by the savings to the economy as a whole and getting dragged down into these disputes. So lastly, I said I'd turn to the IBQC guidelines. All I really want to say about those, in light of Philip's very careful taking us through those, is that underpinning those guidelines are these thoughts that you need a state-funded, open and transparent tribunal, staffed with competent people who will have the confidence of the parties, and provide them with a fair and fast and efficient method of resolving their construction disputes. So that's really all I wanted to say. Thank you very much, Kim.
Thank you very much, Mark. And I've been a co-speaker on 2 conferences with you in New Zealand, and you are typically eloquent and loquacious and very, very informative. That was excellent. And if we had an audience, I'd be saying to extend a hand to all of our speakers for that matter, if we had a live audience. Now, finally, you mentioned the challenges with arbitration in terms of, I suppose, Main Street, the punters, if you will, rather than its important relevance in high-end commercial disputes. And Justin Cotton, who's been with Lovegrove and Cotton for 21 years, as the next speaker. He's been with my firm, well, our firm, since the turn of the century. And interestingly, when I interviewed him, as it transpired, he told me that I used to teach his younger brother at Bucklands Beach Intermediate when I was a teacher whilst I was doing my law degree. So it's a very, very small world. Justin is the director of Lovegrove and Cotton, the chair of the Housing Industry Association Victoria, and the Industrial Relations and Contracts Committee. He's a construction lawyer of 21 years standing. And Justin's talking about quite an interesting theme. Why did arbitration lose its relevance in the residential dispute resolution sector in Australia? Thank you, Justin.
Yes, thank you, Kim, very much. And hello, and everyone, and good evening to you. It's Justin Cotton here, and I'm the head of practitioner advocacy at Lovegrove and Cotton. And I've been practicing in construction and, to a lesser extent, planning law for the last 21 years, pretty much exclusively with Lovegrove and Cotton. In this presentation, I'll be talking about the factors that led to the demise or less relevance of arbitration in domestic building disputation, particularly in Victoria, Australia. Now, in Victoria, arbitration was effectively made illegal with regards to the resolution of domestic building disputes in 1995 by way of the promulgation of the Domestic Building Contracts Act 1995, which governs domestic building in Victoria. Prior to this, nearly all residential building contracts had arbitration clauses in them, and most of those contracts were generated by industry standard Master Builders Association or Housing Industry Association building contracts, which had those arbitration clauses. But since 1995 and the introduction of the Domestic Building Contracts Act, Section 14 has basically prohibited the use of arbitration clauses in domestic building disputes in Victoria. That reads that any term in a domestic building contract or other agreement that requires a dispute under the contract to be referred to arbitration is void. Now, why, in trying to work out why that came to be, I took the opportunity to speak to Professor Lovegrove, Kim Lovegrove, who has had a long period of expertise in this sphere. And he talked about some of the factors that led to this somewhat dramatic change in relation to the relevance of arbitration in Victorian domestic building disputation. Now, there were seen as certain disadvantages to arbitration which led to this change in the Domestic Building Contracts Act. The first was the cost of arbitration. That and if we're going back to, say, 25 years ago when this change came about, the arbitrators could cost anywhere between $2,000 to $3,500 a day, which the parties would then share 50% of the cost of that arbitrator. They'd also have to pay for the room hire and transcript and so on and so forth. That was seen as a real disadvantage of arbitration. There was also the lack of the joinder power to join multi-party defendants, other defendants, for example, an architect, engineer, building surveyor or subcontractor that was not part of the direct building contract, domestic building contract between the builder and the owner. And obviously, as we know, dealing in the construction dispute sphere as construction lawyers and participants in that, we know that often there's many parties that add to the mix in relation to building defect disputes in particular. So that was seen as a real disadvantage with arbitration. There was also the perception on the part of certain consumer lobby groups at the time, this is back in 1995, of a potential bias or lack, or at least a perceived bias or lack of neutrality with some of the decisions, and the fact that because the appointers of the arbitrators were the industry associations for builders such as the MBA or the HIA, and many of the arbitrators were retired builders or contractors, that there might be a bias in relation to some of the arbitrators and some of their decisions. Next slide, please. And as we know, nearly 100% of the building contracts were produced by these major industry associations such as HIA or MBA, and these are the contracts that had the arbitration clauses, with the Commercial Arbitration Act 2011 ultimately governing the jurisdiction and matters that went to arbitration. So a further problem was the lack of neutrality, as well as the inability to join co-defendants to the arbitration, and the perceived cost, which was not the perceived cost was not such a factor if there was to be a specialist tribunal, such as we had with the domestic building list, as it was then called, and VCAT, now called the building and property list, where the parties don't necessarily pay for the member to be the arbiter of fact if a dispute goes to a final hearing. Obviously, they'll have to pay for hearing fees if you're the applicant, and also a filing fee to also start the proceeding. But they don't have to fund the cost of that arbiter of fact, and they don't have to pay for the room hire. So given that a lot of the participants in arbitration 25 years ago were homeowners as well as builders, it was seen as a real barrier to homeowners to have to fork out this money for an arbitration when they have mortgage obligations, and the legal fees are not necessarily tax deductible at the same time either. So cost was certainly one of the factors. So coinciding with the promulgation of the Domestic Building Contracts Act, there was the creation of the dedicated list for the resolution of building disputes, which was the Victorian Civil and Administrative Tribunal, more shortly known as the VCAT, and the dedicated list, now called the Building and Property List at VCAT. That came to prominence in about 1998, following a few years after the Domestic Building Contracts Act. Many of the members, obviously previous lawyers, some had engineering or construction backgrounds, so they could bring that expertise from the industry, combine that with their legal knowledge, and be the triers of fact in the specialist domestic building jurisdiction. There was also similar legislation in New South Wales by virtue of the Home Building Act 1989, a slightly older act, obviously, but also the what was formerly called the ACAT, but then changed its name to the New South Wales Civil and Administrative Tribunal, or NCAT. Next slide, please. So effectively, both these states have dedicated acts of parliament that govern and promulgate the legislative content of residential building contracts. We know that Section 31 of the Domestic Building Contracts Act in Victoria has a list of ingredients, if you like, as to what should be contained in terms of consumer warnings and consumer safeguards in a domestic building contract that is over $16,000 in value. So the net effect of the legislation that governs or is specialist to residential or domestic building disputes and contracts is that there's a dedicated tribunal that devotes itself to the resolution of domestic building disputes rather than relying on arbitration. The government, as it were, funds the tribunal members and mediators before you get to the final trial. The parties do not have to pay for the deployment of the dispute resolution arbiters, as they would with an arbitrator. So effectively, their retention is essentially free, although there are, as I said, filing costs and hearing fees if it does go as far as the final trial. And importantly and significantly, these tribunals allow for the joinder of multiple parties as defendants or co-respondents, whether that's an architect, building surveyor, engineer, responsible for design, building surveyor for certification, or possibly a raft of subcontractors. So that means that everything can be consolidated in one proceeding rather than have multiple proceedings, whereas arbitration is confined to the parties to the building contract and doesn't allow for multiple parties to the dispute resolution. So to conclude, and if commercial and civil disputes are dealt with primarily in a tribunal or court. In Victoria, it's more commonly, depending on the amount of dispute, the county court or Supreme Court. Although arbitration is still legal and allowable and can maintain a role in some commercial and civil construction disputes. Whereas domestic building is primarily in the VCAT, although there has been something of a shift away from that in recent times due to the backlog of cases. In the VCAT, we're seeing cases play out for more than 2 years, sometimes 12 months between the final compulsory conference mediation and the first available date for a trial, unless the trial is going to be 3 days or less. So that's a terrible backlog. It's got worse since COVID. And there is an ability to initiate proceedings also if they're domestic in the building list in the county court in Victoria, whereas up until 2 years ago that was pretty much unheard of, and it was regarded as VCAT having exclusive jurisdiction for these domestic building disputes. But having said that, you can still expect a mediation generally within 6 months of lodging a claim at the VCAT. After the initiation of legal proceedings. We cannot see on the horizon any prospect that there will be a move back to arbitration. There have been suggestions in some of the industry associations that maybe arbitration should come back in as an option, even for domestic building disputes. But due to the disadvantages of arbitration in domestic building disputes, particularly where homeowners are involved, I believe it's unlikely that will be seen as a serious consideration anytime soon. So having the dedicated list at VCAT, despite its current problems with backlogs, has an ability to have mediations and compulsory conferences during the process. I believe that system's likely to remain for the foreseeable future. So I'd like to thank you for listening, and it was a pleasure to come along and speak to you tonight. Thank you, Kim.
Thank you, Justin. Yeah, a couple of things. It was interesting to Justin to mention this topic, the notion that by law arbitration has been made illegal in the residential construct. It's quite unusual. It's also very, very important to note, as a matter of fact and record, that the perception of biased was a perception harbored by some consumer lobby groups. It was never, ever proven, categorically never proven, but some of these consumer lobbyists used to push that point of view fairly vigorously, absent any evidential background, because there was never one instance I can recall, Philip, where an arbitrator was ever found to have been biased at law. Would you agree with that, Phil? Yeah, that's a yes. Now, We've gone very well, and we've got 20 minutes for questions. So now I'm going to show my computer illiteracy here. This is Judge Madot Tesfaye. Judge Madot Tesfaye is a federal court judge in the great nation of Ethiopia, and she's just messaged through, thank you. And it's wonderful to have a member of the Ethiopian bench that's participated in this forum, and on point, His Honour and Her Honour. And I will probably be cooperating with Judge Madot to develop some protocols that could well be of assistance to the Ethiopian bench in front-end ADR within the residential, within the building industry construct. Now, just going to access chat. Okay, so one of the questions is, how do you think court annex mediation mechanisms play a role in designing effective dispute resolution systems? How do the guidelines deal with this? And secondly, how can single joint expert witnesses address the inconsistencies where expert witness reports are based on different or divergent theories? Who would like to deal with number one? How do you think court annex mediation mechanisms play a role in designing effective dispute resolution systems? Who would like to deal with that?
I can deal with the first one. So we have a court annexed mediation mechanisms in our land and environment court system. We have built into the membership of the court both judges who are obviously legally trained, as well as technical experts. And the technical experts are then used for the consensual mechanisms of mediation and particularly conciliation. Why that is useful is because conciliation differs from mediation in that the conciliator not only facilitates negotiation between the parties, but can also proffer solutions using their expert and technical knowledge as to how the dispute might be resolved. Like all consensual mechanisms, they can't impose their view, but they can raise as suggestions for the parties' consideration. And that is highly effective. So turning to building construction disputes, if you had within the court technical experts with expertise in the issues that are the subject of dispute, then they could suggest mechanisms for and solutions for resolving the dispute, which the parties can consider. We find that there is a high rate of settlement where we use these technical experts as conciliators. So it is highly effective, and the guidelines, whilst not specifically addressing that, accommodate that system that I've said, that a court should have in-house experts who can act as mediators and conciliators.
Thank you, Your Honour. Now, second question, how can single joint expert witnesses address the inconsistencies where expert witness reports are based on different or divergent theories? Well, here's the thing. That which has been recommended is that there would not be experts for the plaintiff and the defendant. Rather, there would be an accredited panel of experts appointed by a government agency for the courts to utilise, and they would be chosen on the basis of being venerated by peers of good repute. They would be the very best. I mean, in the Building Appeals Board in Victoria, for instance, if there's a dispute to do with the building permit, it's appealed, or a prosecution, it goes to a thing called the Building Appeals Board, where you've got three part-time members, typically a lawyer, a building surveyor, or an engineer, and they're called upon to preside over a particular matter. Typically, the hearings take no more than a day and a half. And that's a fast-track de facto expert witness mechanism. The key thing is, whilst there is a plaintiff and defendant adversarial dynamic that remains in play, then one's going to repudiate the ability to get a more cost-effective, arguably neutral quasi-officer of the court expert determination. So there's an assumption there, and I think in the question, that you're going to have a continuation of plaintiff and defendant expert ping pong, but that's not the position that we're proffering in this conference.
Kim, could I make a comment on that also? An area where this question might be particularly relevant is in relation to delay claims, where there is a number of theories about how delay ought to be analysed, and the Society of Construction Law in the UK has a very good paper which identifies those theories. Now, I would think that if you had a single expert of the quality that you've mentioned, that single expert would be aware of the various theories that might be relevant to a particular topic. And whilst that particular expert might favour a particular theory, I would think it would be part of that expert's obligation to the court to draw to the court's attention the existence of alternative theories, perhaps what the key differences between the various theories are, and to identify why this particular expert prefers a particular theory to other theories. So I don't think that you'll necessarily lose the opportunity for the court to be presented with alternative theories and to come to a view about those theories. And I would imagine that if the court was disturbed enough about the difference between the theories and felt that it did not have enough information before it in order to come to a view on the divergent theories, then the court could address that by calling for some further evidence if it felt that was necessary.
Indeed.
Something to that too. Kim, just picking up on what Philip said and adding to that also is that all good experts will, and certainly with the Code of Conduct in New Zealand, are required to state in their evidence the assumptions their opinions are based upon. And all good experts will say on the assumption that my instructions are these are my instructions, and on the assumption that this is what the trier of fact finds, then my opinion will be this. But equally, if the contentions, the factual contentions of the other party are accepted by the tribunal, my opinion will be that. So there's no reason why a single expert can't and should not address different sets of factual assumptions that might lead them to a differing opinion. And in fact, they'd be very foolish not to do that.
Thank you, Matt. And before I hear from His Honour, I'd just like to mention, Her Honour, I was very, very interested to see what an extraordinary strike rate has been facilitated through the single expert witness protocol. That's tar on the ground. The proof's in the pudding. Your Honour.
So we obviously, as the category judge said, concept of single parties experts was pioneered in the Land and Environment Court, and we had great experience with that. It is common actually to have divergent theory. So as was just said, experts are required not only to say the facts and assumptions upon which their conclusion is based, but also the methodology by which they input those facts and assumptions to reach their conclusions, their opinions. Now, how do we deal with that? It comes up front when the instruction is given to the expert. So the parties have input into the instruction to the single parties expert. And so they can ask the expert to consider different methodologies, different theories, and say what would be the outcome if one applied a different theory. So the expert will then proffer which they say is the preferable one, but at least the expert is able to say what would be the differences. That means that a party is not disadvantaged by not having adduced its own evidence. There is a clinical application of the theories by the one party, one expert, but the outputs from application of that theory or methodology can be seen, and there can be, questioning by that single party's expert, and ultimately submissions made to the court as to, which outcome, depending upon which theory, should be preferred. So this can be an issue, but it's overcome by allowing the parties input into the briefing of the single party's expert, and the single party's expert then, or court-appointed expert, dealing with the competing theories and saying what their opinion is as to what is the preferable one.
Thank you, Your Honour. Now, the other thing is we've got participating on the panel too, Nicole Mayer, and Nicole is a county court division lawyer. Nicole, feel at liberty to chime in with any offerings that you have that you think are apposite.
Thanks very much, Kim. Don't have anything as yet, but I've just seen a couple of other questions that maybe if no one else has comments on, I might be able to chime in on. Thank you. It's great to be here. Great discussion.
We've got a question from Her Honour Madot Tesfaye of the Federal Court Bench in Ethiopia. Question is, how do you think court annex media? Oh, no, we've already dealt with them. That just came up late. Sorry, forgive me. Now, I think we've got another Ethiopian judge, quite possibly here. How does briefing of the single experts go? Does the inevitable adversarialism move to disagreements on the briefing process? When an impasse is reached, what parameters would a directions hearing consider? I think His Honour's touched on some of that. And the issue of self-representation. I'm mindful of the fact that we've only got 5 minutes to go, but are you able to, Your Honour, to just tackle that?
Yeah. So the central point is, as the Court Procedure Acts throughout Australia deal with it, and that is that the court is in charge. So the court has the duty to ensure the just, quick and cheap resolution of the real issues in dispute. And that means that includes this avoiding sort of the adversarialism of having parties own experts by appointing a court-appointed single expert, but it also then includes ruling upon any disagreements in that briefing process. So what would happen is you would have a directions hearing insofar as the parties were not able to reach agreement as to what the brief should be to the single expert. The parties would say what their respective positions are, and the court would rule on that. And then the court would make the direction as this is the instructions that shall be given to the expert. And so it's a case of the court keeping control of the process, mindful of meeting that mandate of just, quick and cheap resolution of the issues. I'll go to the second one about the self-representation. Again, that is overcome to some extent by what I've just said, that the court stays in control. And so that means that insofar as there is an imbalance in power between the well-resourced and well-lawyered party and the self-represented party with fewer resources, by the court being the one that makes the decision, it evens up the scales.
Now,
Kim,
sorry.
No, go ahead. Sorry, if you're tight for time, that's fine. No problem.
No, Nicole, I'll hear from you before I just conclude. mindful of the fact that we've got about 3 minutes to go. I just need to sum up. Nicole, go for it.
Thank you. I just want to add to His Honour's comments, I guess, that in our experience, we certainly have had issues with agreeing on questions between represented parties, and often now the division lawyers will be involved to sort of facilitate effectively case management conferences to try and resolve those disputes by consent. And what that's often led to, not that I've done many of them, but it has led to in the occasions where it's arisen, is actually more clarity on what the issues in the substantive dispute are. So it actually aids that sort of narrowing of the issues and furthers the purpose of the Civil Procedure Act. So we're finding it's beneficial in that sense as well. So I just thought that might be worth chiming in.
Thank you for that chime in, Nicole. Now, with 2 minutes to go, I'm going to wrap everything up. I think it's been a sensational evening. This conference has been 18 months in the making. Part of the challenge is getting, a high cast of venerated speakers, which, needless to say, has occurred. They've all put in a phenomenal amount of work, some in terms of generation of good practice guidelines, others preparing paper and taking time out of their busy schedules to address this international conference. Tomorrow is the second session, and that's with an emphasis on the Northern Hemisphere in mind. Her Honour Francis Kirk and CBE will be addressing that conference. Some of the key takeouts are criticality of front-end mediation, the merits in single expert witness testimony. There have been some very good templates for best practice on point, provided courtesy of His Honour and Her Honour. Also, the fact that dispute resolution as a horses for courses situation, arbitration is a fantastic mechanism for higher dollar value dispute scenarios. And for instance, there are some countries that do not have a advanced judicial infrastructure because of economic constraints. My personal view is arbitration is paramount in that setting, particularly for PPP disputes, when one can access a high level of expertise from a nominating body abroad. So it's a horses for courses scenario, but we are very confident that if reforming jurisdictions embrace the good practice guidelines that have been generated by the IBQC, then there will be significant cost savings. And these thoughts have been reinforced by the fact that we've got tar on the ground examples that have been proffered by His Honour and Her Honour. Thank you so very, very much, all of you, for participating tonight. Sorry we couldn't get to all of the questions, but we've run out of time because we'll be streaming out. And have a great evening, have a great morning, and all good. Thank you.
Thank you.
Thank you, Kim.
Thank you, Kim. Thank
Thank
you,
you.
IBQC. Thank you, everybody. Thank you.